Welcome to the UNSECURITY podcast. Each week, Evan and Brad give an inside look at current information security news, breaches, best practices, and other things you should know to improve your information security. Here are your hosts, FRSecure's Evan Francine and Brad Nye.
And welcome back. This is episode 57 of the UNSECURITY podcast. I'm your host this week, Brad Nye. Today is December 9th, and joining me is my co-host, Evan Francine. Good morning, Evan.
Good morning, Brad.
How are you today?
Still too early to tell.
Yeah.
Even though I did get up. I got up super early this morning. Monday mornings, for me, some reason, I don't know, I got up at like 3.
I got in before the snow.
It's snowing?
Yeah. It was snowing when I came in. Fun. It's not supposed to be too bad. Only, I think I saw 2 to 4, 3 to 5, somewhere in there. All right. We have a great show planned today. This is the second part of our first 2-part show, and we welcome back our favorite data privacy attorney, Justin Webb. Hi, Justin.
Hey, guys. How's it going? Back again.
That's right. We called you our favorite. Does that mean anything?
It means actually very, very much to me.
Yes.
All right. In last week's show, episode 56, we discussed quite a bit. We talked about the Target lawsuit against Chubb and China's cryptography law, and we had intended to talk about the California Consumer Privacy Act, or the CCPA, but we decided to move it to today's show in order to give it more of the attention it deserves. So before we dive into the CCPA, let's check in quick. How was everyone's week? Justin, we'll start with you.
Busy. Just spending time working with clients on CCPA. It's been pretty gangbusters in December. I think everybody is sort of feeling the pressure. And so we're spending a lot of time working on privacy policies, working on people's sort of data subject requests, forms. And so it's a lot of CCPA stuff and a lot of sort of cleanup at the end of the year. So a lot of hours, but good times. And we had this webinar called We're All in This Together. And I think that's pretty accurate because if you talk to some attorneys, they would refer to the CCPA as a dumpster fire. I think there's a professor in California, Eric Goldman, who did a post on his blog about it. And he just had a picture of a dumpster on fire. So I think that's pretty accurate. A lot of people are happy about the law and privacy rights, but I think a lot of people think the implementation and the language leave much to be desired. So it'll be interesting to talk about it today because I think everybody is confused. So good times had by all.
Yeah, sounds about right. My week, I was busy, shocking, end of the year. Everybody's, scrambling to get this stuff done and, doing a lot of the 2020 planning and wrapping all that stuff up. And, it's one of those things. I think I came in, the latest I was in the office last week was like 6:30. Was my late day.
So you slept in.
I slept in that day. Yeah. Just, it's that time of year.
Yeah. When everything's just kind of nuts.
Yeah. Everybody wants their last minute. Oh, well, we've got budget dollars to spend, or we need budgeting for next year, or we need the assessment done by the end of the year because we have to for regulatory. We waited till, 49 and a half weeks into the year to decide that.
Security is not an afterthought, is it?
No. How about you, Evan? How was your week?
Well,
you had a light week.
No,
light for you.
Did I?
I thought so. Weren't you only in one place last week?
Oh, yeah. Yeah, I only visited one city.
See, that's light.
Yeah, it wasn't too bad. Well, before we got started, we were talking about what happened this weekend, and I couldn't remember this weekend. But let's see, I was in Phoenix, Arizona, Scottsdale, which doesn't suck, by the way, for December, when you're from Minnesota. Hit up 3 barbecue joints. You got to get your priorities straight. So I was down there for the ISSA Q4 chapter meeting. Very well attended. 75, 80 people were there. I was speaker number 3 out of 4. Okay. It was a full day event. Barbecue joints I went to, Naked Q. That was really good. Little Miss was the winner last week. If you ever follow the evanfrancing.com, you can find the roadshow.
I had to quit because I was just getting jealous and my mouth was watering.
Yeah. So we hit 26, 27, and 28. That's the number of barbecue joints we've visited on the roadshow. Little Miss was the best for this week. Met some really, really cool people. Met an ISSA Hall of Famer, a guy named Rich Owen. So we're connected, and hopefully we can collaborate together on some things. But yeah, really, really awesome event. So yeah, and I got back on Friday.
Yeah.
Midday.
Yeah, saw you Friday afternoon. It's cool.
Yeah, it's a good week.
All right.
We should bring some of that weather up here.
Yeah. Did you see the highs like Tuesday and Wednesday? Yeah. I'm
going to Dallas though this week later.
Yeah, I think tomorrow high's supposed to be like 3. Wednesday is like 1 or 2.
Not cool.
Yeah. So you'll enjoy Dallas.
I will.
All right.
Pecan Lodge. That's the barbecue joint down there.
Oh yeah.
I gotta go. See, we went there before, and it's the leader right now in the S2 Roadshow Barbecue Challenge thing that we're doing. I went to Little Miss though this last week, and I was telling John, I'm like, I don't know if this was better than Pecan Lodge or not. We should go back down there and
I think
check
you have to verify.
Yeah, so
validate.
It's our cross to bear.
There you go. It's tough life. All right. So now we're going to get into this whole CCPA thing. So most of the show is dedicated to this discussion. On Evan's blog, there are 3 different references. One is from the California government site, CSO Online, and one from Deloitte around quick reference guide. So I guess first we'll just kind of start talking about what the CCPA is.
Well, yeah, first off, I wanted to talk to Justin and just get his take on. Justin, I assume you probably checked out those 3 references.
I did, yes.
What were your thoughts? Were those pretty good references to share?
Yeah, I mean, the first one is a link to the Attorney General of California's page, and it's got sort of like all the information that you need about the statutes and also the regulations that the Attorney General put out back in October. And those are sort of the Attorney General's interpretation of the statute. And I think much to some people's chagrin, they kind of expand on what's in the actual law. And so there's been some chatter on the internet that, those things may be subject to legal challenges because they expand. So typically when you have a legislative body that drafts a law, like let's say Congress or the California legislature, and they delegate the right to an executive branch to interpret the law, or any other branch for that matter, they're supposed to stay within the confines of the law, right? So like you explain it more, you sort of provide guidance to people, but you don't make new law. And so the Attorney General of California has certainly made new law in the context and in interpreting things. You inherently are making new law, but you're supposed to stay within the confines of the law, and that just hasn't really happened here. There are additional requirements, but yeah, that page has got a lot of the good information, and I think a lot of people, or at least some that we've run into, aren't aware that the California Attorney General has put out regulations, and they're much more specific about what you're supposed to do under CCPA. And so if you haven't looked at those yet, or you're just operating off the law, you should absolutely look at those because they have additional requirements that are pretty important.
Yeah. Well, and one of the things, I mean, every time they come out with a new law, it's, for me, I just give me the kind of the nitty gritty, I mean, what do I need to know and what do I need to implement? And I thought and I don't like to give Deloitte any more credit than they're going to get right now. But I thought their little 2-page quick reference guide was a pretty good guide. What did you think of that one?
Yeah, I thought it was pretty good too. I mean, I think, whenever you talk to an attorney, right, he's going to say, well, there's so much more detail and a lot of like nuance in the law. But I mean, as a general matter, it hits the high points that you need for CCPA. And I think, the recommendation of any attorney, of course, is that you should work with an attorney on your CCPA compliance, because there are a lot of gotchas in the law, in my opinion. And it's absolutely confusing. So if you are just reading it, and you're not an attorney, I would not be shocked if you had absolutely no idea what you were supposed to do. And so it's good for sort of all of these secondary sources that are interpreting the law to help people understand sort of the high level requirements, because it is, even to us attorneys, there's an article that came out, I think, on Friday from Courthouse News that talked about the last public hearings for CCPA. So the Attorney General has had multiple public hearings. You can see those dates on the Attorney General's website. And at this last one, they put up this news story that says businesses confused over terms of California's new privacy law. And I can send the link over to you so you can share with everybody. But one of the attorneys that they quote at these public hearings, his name was Todd Smithline, and he was sort of picking on the law, probably like a lot of other people wish they could. And one of the things he said is, quote, "Let's face it, this thing was essentially written by a broken robot." And it was sort of meant to capture what I think a lot of attorneys and others have thought, which is that, it's still that the law still contains sort of internal inconsistencies. There were a bunch of cleanup bills that went through to try and clean that up. The governor signed, I believe, 8 amendments to CCPA, leading up to the Attorney General regulations that came out. And so the law has continued to change even since it was sort of quickly implemented and quickly passed. And so I think the sort of bottom line is so when I go back to sort of the webinar we had, which was, we're all in this together, which is, everybody is trying to figure this thing out. And so I try and encourage people not to get too discouraged by the lack of clarity in the law. And that's, sort of the main reason why you need an attorney to kind of help you wade through the morass that is CCPA.
So what you're saying is a law that was written in 7 days.
When you said
isn't clear,
when you said morass,
I know.
You said morass. Did you mean morass? Morass. That's a weird.
Yes, it was. It was proposed as a ballot initiative, and the California legislature. When you pass something via a ballot initiative, the only way you can change it is by another ballot initiative. The legislature can't modify something that's sort of the people of the state of California have approved. And so the legislature can propose the same bill in the legislature and therefore and get the people who propose it on the ballot to agree to withdraw it, so long as it's the same bill. And so then the legislature can make changes to it. They obviously have. And so it was a quick process. If you talk to the people who drafted CCPA, they'll say, no, it wasn't. We had been talking to the legislature for a long time. But it's hard not to think that there was some, quickness to it because it was introduced and passed within 7 days. And it didn't go through, at least in my opinion, or at least it doesn't look like it went through the kind of cleanup, harmonizing that you would normally see in a comprehensive privacy law. So if you look at GDPR, it makes a lot of sense. And granted, it was based on a previous law, the previous European data protection law. And so I think that sort of clouds the entire sort of interpretation and implementation of CCPAs as sort of original sin, if you want to call it, of having this thing go through pretty quickly and still remaining pretty confusing.
So for our listeners, we have a series of questions that we put in the show notes. And one of those was, I think sometimes we just assume that people know what CCPA even is. So let's just, if we could just maybe start there. What is CCPA?
So CCPA is the California Consumer Privacy Act of 2018. And so it effectively is a law that talks about what companies, and the law uses the term businesses, are supposed to do with regard to personal information. So it provides things like the right for people to ask for the categories of information that a business collects, It defines relationships between businesses and service providers who handle personal information on their behalf. It provides penalties for failing to comply with the law that can be enforced by the Attorney General. And it generally requires a few things. The first is that you update your privacy policy to have specific disclosures, sort of how you use information, who you share it with, whether you sell information. And a lot of the law is focused on companies selling personal information. So, and one of the amendments that came later on was sort of this data broker amendment, which was meant to capture companies whose sort of primary business is selling information. So the law provides you this right to sort of click on a button or a link that says, do not sell my information. And that company or business that is collecting the information is not permitted to sell it to a third party. And so that's meant to sort of give people this opt-out right from selling of personal information. It requires the disclosures that I talked about in the privacy policy. So sort of how are companies using information? Who do they sell it to? And then it also allows consumers to make requests to see the actual information that companies have of them, to require them to delete that information. It gives a right of data portability, which means not just sort of showing me the information that you have, but actually giving it to me so I could take it and give it to another company or do with it what I may. And so it provides all of these rights and defines relationships between parties, provides penalties. And so the major components of it are for companies who are trying to comply with it are updating your privacy notice either to be to provide everybody the rights or just individuals in California. I think a lot of companies have made the decision to just provide these rights to individuals in California because it's a California specific law. And then providing a way for people to make those data subject requests. So to delete or do not sell my information or provide me access. The law requires you to train your employees about CCPA and handling requests. And it also sort of has this inherent requirement to negotiate agreements with third parties to make sure, actually agreements with service providers to make sure that they aren't using personal information for their own purposes in a way that would sort of constitute a sale of personal information. And the concept of selling personal information is sort of one of the more confusing parts of the law because selling personal information isn't like I give you my social security number and you hand me a $5 bill. It can also be I give you my social security number and you are allowed to do something with that enriches you. And so even if I don't give you don't give me monetary money back. And so it's called sort of like providing the information and obtaining anything of value or for valuable consideration. And so that's where a lot of people get stuck on the law. And really what it means is if you're giving information to a service provider, they can't just do whatever they want with it. They can only do what you've told them to do with it, which is kind of a GDPR-like concept.
So it's simple then, is what you're saying.
Oh, yeah. Very simple. Very, very simple.
I mean, realistically, at the core concept, it really isn't that hard. It's just what are the requirements to actually do that? Yeah,
I don't know. This looks very, very disruptive.
Yeah. Well, I mean, from a basic perspective, right? You can't use my information without my consent, or is really what they're saying.
Sure.
Yeah, and actually the law doesn't really. So GDPR says like you can't process personal information unless you have a legitimate sort of purpose for doing that. CCPA doesn't have something similar. So it doesn't really restrict what you can do with personal information except with respect to sales of personal information. So
okay.
There are a few restrictions in there, but the large portion of the law is just telling people what you do with the information. The only real restrictions are you can't do with information, things that you didn't disclose to people. You can't collect information from individuals if you haven't provided them some notice of what you're going to do with it and what you're collecting. And there's some restrictions on like additional sales of personal information. So if I sell personal information to a company and it wants to sell that information again, it needs to get opt-in consent from individuals to do that. But for most purposes, it doesn't provide that many limitations. It's mostly a limitation on sales and mostly sort of a providing notice through a privacy policy.
Okay.
Now, you brought up GDPR a couple of times in sort of your discussion. And I've heard other people make comparisons to GDPR between CCPA and GDPR. How are these two things similar, other than obviously they both deal with personal, private information? But how are they similar? Is that an easy answer, even?
Yeah, I mean, it's somewhat easy. I mean, I think they're both similar in that they require notice to individuals of sort of like what you're doing with information in varying degrees. They both provide individuals with those data subject rights. So the right to tell companies not to do certain things with information, to provide you a copy of what information they have about you. GDPR is much more comprehensive. It has additional things like data minimization, which means, only collecting, the smallest amount of information necessary to sort of achieve your purpose. It also has the right to sort of like make sure a company has accurate information, which is not something that CCPA has. But for the most part, they cover sort of notice and data subject rights. GDPR expands on that and actually requires sort of like opt-in consent in certain scenarios. And there isn't really any opt-in consent portion of CCPA other than for minors. So individuals under 13 have to have opt-in consent from their parents. And people between the ages of 13 to 16, there's sort of additional requirements. And so one of the sort of hard parts of CCPA is if you're collecting information from individuals, 16 and under. But otherwise there isn't a lot of opt-in consent. It's all sort of opt out of the sale of personal information.
So if a company says, "Yep, we're GDPR compliant," are they safe to say they're CCPA compliant? Are there additional, different things that they'll have to have in place, or?
Yeah, so they're not. I think they're much closer than a U.S. company that's never had to deal with GDPR, because they're familiar with sort of the data subject rights and, sort of providing personal information to individuals. But there's no sort of concept directly in GDPR about do not sell. So at the minimum, you would need to provide the do not sell my information link. And you'd also still have to update your privacy notice to be compliant with the requirements of CCPA. So a lot of companies have, already sort of spent the time to prepare a GDPR compliant privacy notice. And they still have to update it to include additional sort of California terms. And one of the sort of unintended consequences, I think, of all of this is that it's making privacy notices longer. And one of the things the Attorney General said in the regulations is that you need these privacy notices and all of your interactions with consumers to be clear and simple so that people can understand it. But in reviewing, I have this pastime, which I'm very sad to talk about, which is that pretty much every morning I search the internet to see new CCPA privacy notices that have been posted, just to see what other companies are doing and how they're interpreting the law. And in large part, those privacy notices are just getting longer. And so I don't know that actually helps people. It makes it even more confusing as to what a company is doing. And so while I know the law was intended to sort of provide additional clarity to consumers. It'll be interesting to see if that's really true, and I doubt that it is. And it'll be interesting also to see if the Attorney General goes after companies who have sort of, made their privacy notices longer and even more incomprehensible as a violation of those regulations, requiring it to be simple and sort of straightforward.
Well, and does anybody read those anyway? I mean, as a consumer, I can honestly say I don't ever read privacy policies.
I mean, there's a lot of sort of research on this and, a lot of commentary. And I think the answer is that it's not common, unfortunately, for people to read those. I, as a privacy attorney, read every privacy policy that has to do with an app or really anything. I mean, I'll be honest, I don't every time I go to a website read their privacy notice, but if I'm going to give them my personal information, like actually type it in there, I look at it. And even if you don't do that, websites are collecting information from you all the time in the form of cookies, pixels. And so, when people are like, it's really creepy that this ad keeps showing up. It's of course because you're being tracked, across websites and over time. And companies are paying to get their ads placed in front of you multiple times, because the thinking is that you'll go back and purchase that product, whatever it is.
Do you read cookie notices too? Because that's another thing I never read anymore. I mean, I used to read. I read it maybe the first couple of weeks. Now it's just so irritating. I just accept. I think what if consumers do that too?
I'm pretty sure that's probably the case. I think for super privacy-minded individuals, they might spend time looking at that, and some websites that are fully compliant with both the European e-privacy directive and GDPR give you the right to sort of turn off and on cookies. So, there are different categories of cookies, but the way GDPR and the e-privacy directive are read together means that I should be able to say no to certain cookies that I don't want. And so you might see that on certain websites where they have like little buttons that say yes to these cookies or no to these other ones. But no, I don't think a lot of people read cookie notices. I wish the opposite were true, but and
I get the intent. I mean, I get the intent of doing it, trying to empower the consumer, but I fear that we're just reinforcing a behavior that we've seen over and over and over again is, users don't, it's just more noise for them. They just click and click and click. And then the one thing that you actually do want them to read, they're going to click through that one too, because they're creatures of habit.
Yeah. And they're, one of the other things in the new regulations from the Attorney General was a requirement that at the time of collection, so when you actually collect the information from the consumer, so like, right when I'm about to hit submit, or whenever I'm sort of collecting information from people, even if it's a closed circuit television, I have to provide them with notice. So like notice at the time of collection. And that's different than, just posting something in a privacy notice, right? So I've got to tell them before they hit submit that I'm collecting these kinds of information, and this is the, sort of reasons for doing that and what I'm going to do with the information. And so that helps in some sense to provide people notice. And one of the requirements in CCPA that I think a lot of people are challenged with is if you collect information from people offline. So like when I walk into a convenience store in California, if they're going to collect personal information from me, like ask me, like swipe my credit card, which is collecting personal information from me or whatever, they have to post a notice of at least a link to their privacy policy. So what you'll see when you walk into California stores and elsewhere in California, after January 1st is if they have a CCTV camera, you're going to see a notice posted prominently that says, for more information about our privacy practices, go to, xcompany.com/privacy. And we collect, CCTV images for fraud prevention and security purposes. So they'll talk about what they collect, what they do with it, and where to find more information. So it's going to require companies to post a bunch of sort of physical notices in their store when they're collecting personal information from individuals.
Crazy. So who does CCPA apply to? Like we're a small company here in Minnesota, not small. I mean, 80-ish employees with, good revenue, but we don't deal in personally identifiable information. We don't sell it. We don't, we're not that kind of company.
I think the threshold requirements, and these are really important. I think a lot of people haven't taken the time to sort of do that, and they automatically assume CCPA applies to them. And when we deal with clients, we've had some that come in and say, hey, we need to comply with CCPA. And we take a step back and say, okay, before we even go into like the requirements of the law, let's talk about whether or not this thing even applies to you, because the first line of defense, right, is to say we don't even meet the requirements, so let's not even worry about it. So the requirements are you either have 25 million in revenue, or you collect the personal information of 50,000 people in California, and it's 50,000 individuals, households, or devices. And so that requirement has been interpreted to mean even sort of like information that you collect on your website. So it's potentially possible that you could hit that 50,000 California resident or households or devices threshold just by having a website that drops cookies on 50,000 individuals or devices. But there's a little bit of nuance to that. The other is that you would be selling personal information of individuals in a certain amount. But the two main ones are 25 million in revenue or collecting 50,000 pieces of personal information from individuals, households, or devices. And then the other requirement, so even if you meet one of those two, the other requirement is that you quote unquote do business in California. And so this is again sort of a amorphous requirement. It's not defined in the law, which is pretty challenging. There hasn't actually been guidance from the Attorney General on this point. But what it's been generally interpreted to mean is that if you engage in commerce with California, so I have a website, somebody comes and orders a product from me and I ship it to California, that may be enough, depending on what attorney you talk to. But more importantly, if you're a company and you're registered to do business in California, you're probably going to have a hard time arguing that you aren't doing business in California. And so a lot of people have foreign jurisdiction registrations for their company because they might have to pay sales tax in California for internet sales. And so if you have physical employees in California, you're probably doing business in California because you're paying individuals. If you have sales agents, and a lot of that is kind of similar to interpreting GDPR and whether or not it applies to you, even though you're a United States company. But I would encourage, we want to go through like a fulsome analysis with clients about whether or not the law applies. And so it also doesn't apply to nonprofits, with some exceptions. So if you're a nonprofit entity, you will most likely be exempt from the law. So, there's some ways to get out of it, I guess, is a good way of putting it. And so if you're under 25 million, you have a pretty good shot of not being subject to it unless you hit this other sort of information collection threshold.
All right. So to summarize, for-profit companies,
Yes.
$25 million in revenue or more, and then it's or, not and, but it's or 50,000 consumers, devices, whatever, personally identifiable records, I guess. And then there's another or, which is like you sell personally identifiable information, right?
Correct. Yeah.
Okay.
And a certain amount of personally identifiable. So it's actually that you derive 50% or more of your annual revenue from selling personal information. So if like half your business is selling personal information, that's the other or.
Okay.
So for most companies, and I guess it really depends on how broadly you interpret that term sell, which is sort of the, confusing portion of the law. But most businesses aren't going to hit that 50% threshold unless you're like a data broker or you're really sort of trafficking in personal information. I mean, that sounds like drugs, but you handle a lot of personal information and sell it. So those are the main requirements.
Okay. Now, California residents, right? Is this current residents, former residents? Because I know like the Massachusetts data protection law, that was kind of a big thing because it was sort of if you ever lived in Massachusetts, right? Does California work? Yeah. This one work kind of the same way?
Not that I'm aware of.
Okay.
I mean, it's supposed to be California residents, sort of period.
Okay.
So, and the other thing is, it gets a little hairy if let's say you have a website and you're like, we don't want to be subject to CCPA. So we're going to geofence the website, and restrict anybody from California from actually, engaging in commerce. We're not going to ship anything to California to try and avoid the law. You still potentially could have people who are California residents, who flew to New York, or are, checking out Times Square and then engaging commerce with your website. And that's still a California resident, right? I think you might have a pretty good argument that if you cut off all access to California, that you're not doing business in California, but you potentially could still collect information of California residents. And so part of the sort of challenge is, you've got California residents that are not just stationary in California. They move around. And one of the other sort of concepts in the law, which I think is important and still hasn't been fleshed out, is the law doesn't apply to activity that happens wholly outside of California. And I don't think anybody really knows fully what that means. But the way that I sort of interpret it is if you're collecting information from people and generally engaging with them. Like, let's say I'm a Wisconsin gas station and I meet the $25 million threshold. And maybe I do business in California with my website or something like that. But somebody from California walks into my gas station, in Wisconsin, and I collect their personal information. That's all happening wholly outside of Wisconsin. And so the argument would be that CCPA does not apply. Like, I don't need to post signs in my gas station in Wisconsin about CCPA rights if I'm physically present outside the state. But the law is not wholly clear on this point. And so that may be another way to sort of get out of part of the CCPA requirements. And the bottom line for all of this stuff is, just like with GDPR, where, it went into effect on May 25th, 2018, and a lot of companies took the wait and see approach, which is, let's wait and see what happens and then determine sort of how scared we should be by the enforcement actions. That's absolutely the case here. We're not going to know how broadly and how, forceful the enforcement will be on this until we see the California Attorney General actually enforce it.
Yeah, it's going to be interesting on IPs or phone information, right? Because I'm a Minnesota resident and my phone number is not Minnesota based, right? Because people move around, they keep their phone number. How do you ensure, right? Or VPNs, right?
Well, and you mentioned the wait and see approach, and so that would be, let's see what the consequences are going to be. So it's a good segue into what are the penalties for noncompliance. Are those well spelled out in the law?
Yeah, this is one area where it is clear. For the privacy portions of the law, so like most of the law is focused on privacy, but there are some additional provisions that talk about data breaches, and mostly that relates to fines. Or potential statutory penalties, I should say for that. But if you don't post like a CCPA compliant privacy notice, or you don't provide individuals with the data subject rights, or do some of the other things in the law, then the Attorney General is the only person or a governmental entity that can come after you. And the fines are $2,500 per violation if it's sort of a negligent violation, and then it's $7,500 per violation if it's sort of a willful, which means like you knew what the law was and you decided I'm not going to do it, right? And so you sort of had knowledge of it and you intentionally didn't comply with the law. But it's not as if the Attorney General can just come and sort of fine you. There's also a 30-day period to cure. So theoretically, the attorney would come to you and say, hey, you're not doing these things, and you would have 30 days to fix that. And if you didn't fix it within the 30 days, then they could fine you for the money. But it's not clear exactly how that's all going to work in practice. But I think the larger point is that there isn't any private cause of action. So at least on that front, so nobody can come in and sue you like a consumer couldn't file an individual or class action lawsuit against you under the 2,500, 7,500 portion of it.
So that almost seems to reinforce the wait and see approach, doesn't it?
It does. I think it does. The question is, if I just completely ignore the law, right, and then the Attorney General comes and says, hey, you haven't posted a privacy notice and you haven't allowed people to exercise their data subject rights, does that wash, and they give me 30 days to cure that and I fix everything, does that wash away all of the violations of the law? So like the failure to provide people their information, to post a privacy notice, to have certain provisions in my agreements with service providers. It's not clear if that's how it works. Like it's a total get out of jail free card, or, whether there's some other fining that could be done in that area. But it does absolutely reinforce the wait and see approach.
And it doesn't seem, per violation, is that per instance of, per occurrence or per?
Yeah, we noticed you don't have this policy. So that's one violation, or all 50,000 people that you
collected data
collected on is
at
at 50,000.
Yeah.
That and if there are 12 requirements for your privacy notice, each one being you disclose these certain things, are those each a violation of the law? I'm sure you could make an argument that for each sentence in the law, each provision, that's a violation. So I think that's another sort of thing that's unclear. One of the other sort of important points on this front is the Attorney General of California is, one man, and then an office of attorneys, right? But there are, we're talking about a regulation that potentially regulates companies across the United States.
Right.
And so it's not exactly going to be easy to enforce this everywhere in the land. And so the thinking is that the Attorney General obviously is going to try and enforce this in scenarios in which they're trying to make examples and trying to ensure sort of compliance with the law. But the other thing is that, if you're a small company that just barely hits the $25 million threshold, you may not be, the prototypical target of the Attorney General 2 days after the law goes into effect, or I should say 2 days after the enforcement deadline, which is farther. So the law goes into effect January 1st, but the enforcement isn't until the middle of the year, about 6 months later. So the point being that, that's a lot of companies to try and police. And so we'll see how that actually occurs. And I think it's going to be an extreme challenge for the Attorney General to comprehensively police this.
Yeah, so maybe the big name tech companies in Silicon Valley that are based there should be a little bit more concerned than the smaller ones.
Yeah, and that would be consistent with people's opinions post GDPR.
Yeah, that makes sense.
Yeah, it does make sense.
So
if you think about it in a harm sense, right? If you're trying to prevent the most amount of harm, you would be focused on companies that are collecting the most amount of information.
Mm-hmm. Yeah, it does. It makes.
Should go to Equifax and TransUnion and.
Yeah. So the other portion of the penalties is for data breaches. So California's law has a requirement now that you use reasonable security measures to protect personal information. And the modification to the law is that there's now a private cause of action. So somebody can sue you if you have a data breach, and you failed to use reasonable security measures negligently, and that caused the data breach. So the fear for a lot of people isn't even really the privacy portion of this law, but in terms of like pocketbook, if every time you have a data breach, somebody's going to sue you and argue that you failed to use reasonable security measures negligently, and the fine is between $100 and $750 per individual. So you can imagine like an Equifax breach having a significant amount of damages. And those are, I shouldn't say fine. I keep using that word and that's wrong. It's statutory damages, which means the damages that are permitted per individual. So if I was a single person and I sued a company for a data breach, I could get up to $750. Or if my actual damages are higher than that, I could get my actual damages. So like what I actually sort of was hurt or, the effect on me.
Wow.
But the fear isn't, individuals suing under this. It's a class action lawsuit in which you get sued every time you have a data breach. And, there's these statutory fines that are extremely hefty. And anytime you have a statutory, recovery provision in there, I said fine again, I shouldn't have done that. Every time you have a statutory recovery provision, which provides certain amounts, it's very attractive to plaintiffs' attorneys who want to maximize the amount of recovery, because it's not worth it to sue for one individual because the legal fees will probably more than, what you recover, the $750. But if you do that for 1 million people, then you hit the jackpot, and you are highly motivated to sue. And so I think the fear is that this could potentially cost companies a lot of money. And nobody knows what the proof will look like to prove that you sort of negligently failed to use reasonable security measures.
Well, I would say not changing default passwords or things,
But
wasn't it admin and password? That's pretty, but yeah, that'll be interesting.
Yeah, I mean, that one would probably be a pretty open and shut case, I think. Having unsecured Wi-Fi, unless it's like a public network, or, using a password, like God, probably wouldn't get you very far. I think the other thing is that one of the interesting things about California is that the Attorney General, back when it was Kamala Harris, said, here's what reasonable security measures are. They put out this sort of like document that said to be, to have reasonable security measures in California, we interpreted that as complying with the Center for Internet Security, the CIS controls. And so it's the only state that I know of that is actually sort of, and actually that's not true now that I think about it, but it's the only state that's expressly stated one particular framework that you should adhere to prove that you have reasonable security measures. So presumably in these lawsuits, they're just going to cite to this Attorney General opinion and documentation and go to the company and say, look, you didn't use the CIS, top 20 or whatever. I can't remember exactly which CIS controls it refers to. And say you didn't meet those, and therefore you're automatically not using reasonable security measures.
That'll be interesting. So it sounds like right now, my opinion as not a lawyer is for organizations, know what data you have, know what controls you have in place, do some best practices, and just wait and see.
Yeah, I mean, I think what we've told companies, sort of the high level, are do some data mapping, know what information you collect and who you provide it to, and sort of make this analysis of whether or not you sell personal information, update your privacy notice, provide some place, either an email address, an online web page, or a 1-800 number. You're actually supposed to have 2 of those in certain scenarios to allow people to exercise their rights. make sure you've got, in addition to the privacy notice, these just-in-time privacy disclosures. Train your employees and do some work on your contracts to make sure they comply with CCPA. Those are sort of the high-level requirements. But everything starts with knowing what information you have, because you can't update your privacy notice to make all the disclosures required, like the categories of information you collect, if you don't know what you're collecting or, what you use it for.
Yeah, makes sense. So great discussion. Thank you, Justin. Hopefully the listeners get some real value out of this. And a quick housekeeping thing before we get into the news. The quick reminder is the upcoming and new edition of the show, starting after the first of the year. We're going to be devoting about 10 minutes to each show to anyone who's looking for a job in the information security industry. You can email us at unsecurity@protonmail.com if you want your slot. And we will be responding on a first come, first served basis. And we've received several emails, which is really cool. So if you're chosen and the time works out, we'll invite you on the show to learn about you. Think of it as a quick 10-minute interview. No pressure for anyone who wants to do that.
Right. We're going to give you some really challenging questions.
Yeah. So we're working out the kinks between now and then, but we'll have a standard format defined. And if you're using it, I can't talk. If you're looking for a job, use us to help you get the word out. So stay tuned. We'll mention this a couple more times here. And I think it's going to be interesting. It's going to be fun.
I'm excited to meet some new people and help them hopefully land a job.
Yeah. So lots of things this week, but just a couple of news stories. The first one is on infosecurity.magazine.com, 6 customers affected by ransomware attack on CyrusOne. So the big thing here is a data center provider, one of the largest in America, has become a victim of ransomware. So CyrusOne had a attack involving REvil. How do you pronounce?
I just call it REvil.
REvil.
Yep.
I'm not going to pronounce the one in parentheses because that's going to be ugly.
Sodenakambi.
Yeah. Thank you.
I think that's right.
This attack had taken place on Wednesday. Customers of the New York data center suffered loss of service. So 6 of the customers had availability issues. It's not good.
No.
I think we're seeing it more and more, right? They're attacking managed service providers, data centers.
Sure.
And I know we've had a couple calls from data center or MSPs that had some issues and had failures of basic things about segmentation and things like that.
Well, and the and to give CyrusOne, some credit, they do have thousands of data centers all across the country, and not thousands of data centers, thousands of customers in data centers across the country. So 6, in context, it may not be that significant. And it appears as though they responded really quickly. So, I'd sort of kudos to CyrusOne because it's not, you are going to get hit. Right? Oh, no. It's just a matter of time. And then it's what are you going to do to respond to it? Do not pay ransoms. Make sure you have those backups. Make sure they're air gapped. Make sure you can recover. And it sounds like CyrusOne did that. So
yeah. I think.
Yeah, I mean, we keep seeing, supply chain attacks are just crazy. The motivation of attackers is let's get the service provider because we're going to hit a ton of customers. We get 40, for one. And that's happened to a lot of sort of medical software providers in the Wisconsin area recently, one involving dental practices. And as a matter of fact, I think I just posted something else about another sort of dental software provider who was hit. And then another one that sort of helped nursing homes with software. And so it was my understanding, at least from the article, that they were having problems sort of dispensing medication and doing sort of other things that are required of nursing homes because this sort of software was required to do that. So, I think people always think that, these kind of things can take down businesses, but they can also have an effect on your health. It's not just people sort of hacking health related devices, pacemakers, stuff like that for really cool DEF CON presentations.
Right.
But also potentially affecting people's real world lives.
Yeah, that's gonna be interesting
Kind
to
of
see.
scary.
Yeah, exactly. The next one is China fires up Great Cannon denial of service blaster on the register.co.uk. Pretty much just a DDoS tool from a state sponsored. So not a whole lot you can do on that one. Just interesting to read, I thought. And then last one is on hackread.com, new privacy tool exposes which website leaves your data unprotected. Interesting. I think it's a very interesting concept. And I'll be honest, I have not read all the details behind it and what they collect and what the process is. But, basically it's going to tell you using a Chrome extension what the website collects and what they're doing about you. So that will be one to, I think, keep an eye on. So that's it. Episode 57 is a wrap. Thank you, Justin, for joining us and sharing your perspective again.
Yeah, thanks for inviting me back. I'm very thankful to have been the 2-part guest. So this has been great, guys.
All right, so we got another great show planned next week, but we can't let the cat out of the bag yet. Thank you to our listeners. Keep the questions and feedback coming. Send things to us by email. Reading is very hard this morning for me, in case you couldn't tell. Send us email at unsecurity@protonmail.com. If you're the social type, socialize us on Twitter. I'm at Brad Nye, and Evan is at Evan Francine. And if you'd like to get in touch with Justin, you can find him on LinkedIn. Lastly, be sure to follow Security Studio at Security Studio and FRSecure at FRSecure for more goodies. That is it, and we will talk to you all again next week.
Thank you for listening to this episode of the UNSECURITY podcast. We value our listeners and would love to hear from you. Give us your feedback by emailing us at unsecurity@protonmail.com. That's unsecurity@protonmail.com. Be sure to tune in next week to hear the latest insights from Brad and Evan.